Assalamualaikum and good day to our lecturer, Dr. Muhammad Zulkifli bin Muhammad. We want to present our assignment for Usul Fiqh, and our assignment is about Istishab. Before that, I want to introduce our member group. This is our member group: Muhammad, Afiq, Aiman bin Roslan, and then me, Ahmad, Syazwan, Izzuddin bin Abdullah, and then Ahmad, Arif, azwar bin anuar, Muhammad Syafiq bin shajarupi, Erna, Nordiana binti Ramlan, Siti, Nursyahira binti Radhuan, faizah binti muhamad aziz, and then Fatin, Faqihah binti Zakaria. I want to talk about introduction of Istishab. Al-Istishab is one of the sources for issuing laws, but it is not in the category of resources agreed upon by the majority of scholars. Al-Istishab is one of the jurisprudence in Islam. Istishab is a term in Islam that used in the jurisprudence to denote the principle of the presumption of continuity. In the other meaning, Istishab means that a law is maintained at the second time based on its existence at the first time unless they have evidence that there is a change in the law. This means when the mujtahid scholars have studied a law on a matter but do not find evidence of a change of law on that, hence the scholars will use the method of istishab by maintaining the original law of that. Okay, that's all from me. For the other information about Istishab, I give this talk to Nursyahira. Thank you.
Presumption of original absence is istihab al-adamul al-asli, which means that a fact or rule of law which had not existed in the past is presumed to be non-existent until the contrary is proved. Thus, a child and an uneducated person are presumed to remain so until there is a change in their status. For example, by attaining majority or obtaining educational qualification respectively. Similarly, if A, who is trading partner to B, claims that he has made no profit, the presumption of absence will be in A favor unless B can prove otherwise. Another area which is determined by the presumption of original absence is the original freedom from liability or the presumption of innocence, which will be separately discussed later. Furthermore, A is in a doubt whether he has taken ablution or not. The original state is that he has no ablution. The presumption is he has not yet taken ablution.
I'm going to talk about Istihab al-Hukum. Istihab al-Hukum is something that has a law that has been set until it has a specific dalil. If there is something that the law harus, it will continue to be until there is a dalil that says something is haram. There is dalil about Istihab al-Hukum. The dalil is, He, Allah, create for you all that is in the earth. This dalil from Surah Al-Baqarah. This dalil explains that Allah made the earth for human beings and required for human beings. The example of istihab al-hukum are food and drink. Intoxicating drink like alcohol are haram for Muslims, while food such as blood, pork, and animal are not slaughtered, or animals that are slaughtered in the name other than the name of Allah are forbidden to be eaten by Muslims. Food such as chicken, meat, and fish are halal because there is no law stating that food is haram. Evidence in the prohibition of food such as blood and pork can be seen in the Nas and Dalil, namely Surah Al-Ma'idah verse 3. I leave this presentation to Afiq. Thank you.
Let me present about Istihab al-Wujud al-Asli. Differentiate an example, the variety of istihab takes for granted the presence or existence of that which is indicated by the law or reason. For example, under the presumption of original presence, the purchase is presumed liable to pay the purchase price by virtue of the presence of the contract. of sale until it proved that he has paid it. By the same token, a husband is liable to pay his wife the dowry by virtue of the existence of that very marriage contract. In all these instances, istihab presumes the presence of liability or a right until an indication of the contrary is found. The ulama are in agreement on the validity of this type of istihab, which must prevail until the contrary is proven. That's all for me. Thank you. Next, Faizah.
Thank you, Afiq. Ayakila Yuzabi Asha carries the meaning of confident, not lost with doubt. In this method has two things, namely confidence and suspicion. Confidence means a feeling in your present heart when gaining the right belief in something because there is strong evidence. Then suspicion carries the meaning of doubt in your present heart when there is no solid evidence. Therefore, when there is a clash between confidence and suspicion, then that confidence should be considered. I yakin Raisa bin Aisha has a very great position in Islam. In fact, some ulama state that this method includes 3/4 fiqh problem or maybe more. Imam Nawawi said this method is a basic method that covers problem. In addition, Imam Ibn Abdul Bar said the ulama have agreed that the person who has hadas, then he doubt whether he has performed ablution or not, that his doubt did not work at all, and he was obligated to perform ablution again. In conclusion, the method means all that has been determined is not approved by the suspicion.
Istihar azwar, continuity of attitude, such as presuming clean water, purity being attitude to remain, so until the contrary is established to be the case, change of color or taste. When a person has an ablution to perform salah, the attitude of cleanness is presumed to continue until it is released. A method is not sufficient to nullify tahara. The legality of intimate relationship between husband and wife based on valid marriage remains until there is evidence provided to their separation. In case doubt arises as to whether the shirt or skirt that you are wearing is clean, all attached within all animal waste. Thank you. Next to Arif.
Presumption of generally until it's specified. Maxim play a prominent role in the judicial interpretive process such as procedural law, criminal law, transaction law, and family law. Certainty may not be disproved by doubt. Al-yakin la yazul bil ashak. The presumption cannot be set aside by doubt, but by certainty. For the example, the case of husband who pronounced talak to his wife, but he is in doubt as to the precise term of his pronouncement, whether it amounted to a single or triple talak. Imam Malik say triple talak takes place. The certainty is divorce. The doubt is the right of the husband to the revocation of the talak. Some jurists claim that the rule of law in this situation is to be established through the interpretation of words and not by the application of istishab. Ad-darar yuzal walakin la bi ad-darar. Harm must not be eliminated but not by means of another harm.
The argument of al-istibhab. It has three schools have an argument of the istishab, and the first school is the opinion of the majority of ulama from Mazhab Maliki, Shafi'i, Hanbali, and the small number of Mazhab ulama Hanafi. They say al-istishab is an argument either in nafi or isbat. And then the second school is the opinion of the few later Hanafi scholars. These scholars think al-istishab is only an argument on nafi but not on isbat. Then, the third school is opinion of the majority to Hanafi scholars and some of the scholars al-Kalam. They argue that al-istishab is not considered as argument at all. And then next we go to Mazhab Sahabi. Sahabi means in the term of language, friends mean to be friends, to hang out all together, either for a long time or for a moment. Then, after that of Rasulullah SAW, the Muslim community are the companions who really understand the fiqh and the other religious science, and because of this familiarity with the Prophet in the association, so as to able to understand the Al-Quran and the law. After the death of Prophet SAW, many companions who appear to give opinions or fatwa in answering various legal issues that arose. Some jurists proposed to opinion of the companions which called Sahabi. The Sahabi school means to opinion of the Prophet saw on a matter whose law in the non-electricity stated in the Quran or Hadith. And then the companion have issued various fatwa on various events and problems that are very much. Next, we go to Amal Ahli Madinah. Amal Ahli Madinah is the death of people of Madinah in the time of the first companions or tabi'in who are considered inherited from Rasulullah SAW for about the first 3 centuries after Rasulullah SAW migration to Madinah. The hadith about the priority of the people of Madinah from others does not deny the other priorities and does not mean ijma, especially for the people of Madinah, but also open for others. The hadith of Rasulullah SAW was not only heard by the people of Madinah because it is possible that the person who heard it come from another people and did not live in Madinah. The people of Medina know more about the reason for the dislike of the Al-Quran. This is the privilege of the people of Medina. So for this reason, the dates of the people of Medina are preceded by the Qiyas and the Khabar Ahad. Then for the conclusion, Istishab is not independent proof or method or juristic deduction in its own right, but mainly function as a means of implementing and assisting indication whose validity and continued relevance are established by the rules of Istishab. Istishab is often described as a principle of evidence, and it's mainly concerned with establishment or rebuttal of fact. As such, it is greater relevant to the rule of evidence. Then the Istishab will be last ground of fatwa. When jurist is asked about the ruling of particular case, he must search for a solution in Al-Quran, then the Sunnah, Ijma, Qiyas, and Maslahah. Lastly, Istishab was not dynamic topic to mujtahid and applied in the new Islamic jurisprudence because the word the accused person is innocent until proven guilty from Istishab al-Asliyah. Lastly, this is our case study for the al-Istishab. I hope you guys enjoy it and get a benefit from this Istishab topic. See you next time. Thank you.